Just before I return to Amgen, my lords, Lord Mance asked about the German decisions and where you can see they deal with literal infringement and then infringement by equivalence. And I think the easiest way to show this is by reference to our written case in the annex. And that's at Core Volume 1, Tab 10. And on physical page MS 288, paragraph 332.
Page?
288.
Thank you.
In Core Tab 10.
Yep, I have it, thank you.
We've broken down, this is the first judgment in Germany, we broke down into the various elements, and you can see in B, 2 and 3, there's the literal infringement and then the equivalent of infringement. And that judgment is at Appeal Bundle 2, Tab 5, and the crossover between literal and equivalent infringement is at electronic page 848 or physical page 844. And then if you turn on in our case to page 296, paragraph 361, we've again done the same exercise in setting out the various headings in the Bundesgerichtshof, and under 3, they actually deal with the Court of Appeal first and deal with literal infringement, and then they go on to deal with infringement by equivalence. So you can see the breakdown.
Yes.
I'm sorry, my lord.
Yes, fine. Now, the paragraph numbers we ought to be a bit careful of, because I looked at the German and it has different paragraph numbering to yours for some
I do apologise.
reasons. If the German courts are going to read our judgments with interest, they will be surprised if the paragraphs are different. But I mean, I'm not sure you can do anything about that.
Well, we can perhaps hand up a corrected sheet.
You can give us a renumbered English version. Some of the paragraphs have been combined and so on.
Will do. Thank you. So, my lords, I was on Amgen, and we got to the section in Amgen on doctrine of equivalence, starting at paragraph 36. And as we've explained in our written case, an activist hadn't sought to challenge and reply. Lord Hoffman there was looking at the old US approach, where the question was simply whether the inventive concept had been utilised without reference to the claims. And Lord Hoffman says that's the wrong approach, but it's not the approach that's now carried out in the US. They carry out an element-by-element analysis. And so I don't think it's that helpful to spend very much more time on this. All we would say is Article 2 of the protocol clearly requires an element-by-element analysis, and so to the extent that Lord Hoffman is commenting on the old US approach, it doesn't really take things much further. My lords, the next section is where he asks, is Catnick consistent with the protocol? And that's paragraph 45 onwards of his judgment, his speech. Again, we have no issue with the conclusion that the outcome of Catnick was protocol compliant, but the way that it was dealt with in one step, construction only, we do query, and you've heard me address you on that already. So I think that's my summary on that section of the judgment. In particular, at paragraph 48, Lord Hoffman repeats that the second line of 48 is the protocol and Catnick, it's intended to give the patentee the full extent, but not more than the full extent of the monopoly which a reasonable person skilled in the art, reading the claims in context, would think he was intending to claim, as long as that includes in consideration of equivalence. Under Article 2, we have no problem with that, but of course that's not clear in this paragraph at least. Lord Hoffman goes on in paragraph 49 to deal expressly with Article 2, and our position on this is strictly obiter, because Article 2 didn't apply to the Amgen case. Moreover, it's not clear, and as far as we can tell, Lord Hoffman wasn't addressed on the derivation of Article 2 in the cases before him or at the hearing. and therefore it's not clear precisely what he means when he says in paragraph 49, there's no reason why it can't be an important part of the background facts. We say it should go a bit further than merely being aware that equivalence could exist, because as we understand it, due account shall be taken of any element which is equivalent to an element specified in the claims. That's the requirement, and therefore, if the court is not doing that, it's not complying with Article 2. And the outcome should be that inessential variance should be held to be within the scope of the claims unless excluded, and the reader should be deemed to know that with Article 2 in mind. My Lords, paragraph 52, Lord Hoffman goes on to paragraph 50-51. He quotes from Improver and Catnick. But he, again, doesn't deal with a situation in which the patentee didn't have any intention in relation to what he put into his specification and claims, and we say the policy that we've referred to is not taken sufficiently account of in Lord Hoffman's reasoning. He says in paragraph 52 it's not necessary for the improver questions to be asked, and too much weight can be put on these which are merely guidelines. And of course we agree with that. They are only guidelines. The ultimate question is Article 69 and the protocol. But of course, the reason they've been adopted in this case in particular is because activists have sought to bring in Germany and Spain, at least at the first instance, where these same questions form a central part of the analysis. So it was inevitable that the courts in this country were going to look at the questions in this case. And I will respectfully remind Lord Neuberger, especially, of your comments in the first instance decision in Amgen, reported at 2002 RPC 2 at paragraph 67, where you said, rules of construction are servants, not masters, let alone tyrants. They're to be used to assist in working out what documents mean, and they are not intended to be mechanistically applied. And we say that still applies to the improver questions today. My Lord, Lord Hoffman then goes on to examine the facts of Amgen more closely, and at 53 to 62, he agrees with the judge's construction and conclusions on literal infringement, and he holds that the TKT endogenous version was not, doesn't fall within the claims as they should be construed. And at paragraph 63, he explains the difficulty with the reference in Improver to a contextual meaning, and in 64 he prefers to refer to conventional meaning rather than a contextual. And we say that's probably a better way of expressing it, but it is still a problem if all of this exercise is deemed to be an exercise in construction, rather than a separate exercise of working out firstly what the claims mean, and then asking whether they cover equivalence. In paragraph 65, Lord Hoffman goes on to explain that the improver questions only really work where the words are terms of degree, and we respectfully submit that that's an implicit acknowledgement that asking whether a helical spring is a rubber rod is not something that most addressees or even judges would find easy to understand. And that's the problem which arises with trying to do this all as an exercise of construction. And so in paragraph 65, Lord Hoffman concludes that in such cases it's better simply to ask what the invention is. And he then goes on to analyse the judge's analysis of the invention in that case, and he holds that the judge's characterisation was too general in paragraph 67 to 69, and so he upholds the Court of Appeal's decision on non-infringement. And he explains in paragraph 69 that there's only one compulsory question, and he goes on to say that the improver questions are superfluous if you've already done the construction exercise. And we respectfully point to that as being a very good example of where the problem with this approach is if you've construed it without taking into account equivalence, and you say that the improver questions are merely an exercise in construction, then you end up not doing the equivalence analysis at all. Yeah. And that's the problem that we identify. And he repeats this in paragraph 70, where he explains that effectively everything turns on the original construction, and that doesn't give proper room to equivalence as Article 2 requires. And this is particularly when combined with the approach in paragraph 34 of the critical role of language and not allowing the patentee to veer from the literal words of the claim. You end up punishing the patentee doubly, we would respectfully submit, with a narrow construction and then an absence of any equivalence. And the result would be to exclude equivalence in situations where the patentee hasn't considered them, or because at the time there were no such equivalents, contrary to the policy that we've looked at. Lord Hoffmann returns then to the protocol questions in the German approach in paragraph 75, and he notes about halfway through paragraph 75 that the way that the Germans ask the first question may be superior, because he, as he puts it, the question whether it solves the problem underlying the invention by means which have the same technical effect may be better because it doesn't involve an assumption about whether works in the same way involves an assumption that it works at all. This is the middle of paragraph 75. So it's clear that Lord Hoffmann there recognises the problem that we've been addressing and that arises on the improver question about whether you are to assume that it works or not. Now, I'm not sure that the solution, the German solution, necessarily answers it fully because, of course, the question whether it solves the problem underlying the invention by means which have the same technical effect, you still need to know whether it solves the problem or not. So it's not a perfect solution, but it's certainly better, we would respectfully submit, than the working language that was used in the improver. And importantly, we say the focus needs to be on whether it's solving the problem by means which have the same technical effect, and the focus should be on what are the means, what is the way in which the problem is solved, not whether it works at all. Now, we acknowledge that where the invention and the problem coincide, as they did in the American Home Products case, where the invention was providing a new molecule, then if you ask, does that work, does the variant work, you are effectively begging the question, because that is the ultimate question that you're trying to decide. So in certain cases, this won't help, but it certainly does emphasise that the question is not whether it works at all, but whether it works in the same way, and that is helpful, we say, in understanding the proper approach to question 2. He then goes on in paragraph 76 to 77 to determine the case effectively we would submit on the basis of improver 1. He just says that the TKT were not using the same invention. That answers the question. But finally, he comes back to the question of new technology in paragraph 78 to 85. And he starts by posing the question in 78. First of all, first sentence, he says that there isn't infringement. Then the second sentence in 78, he says it would have been easy to draft such a claim, i.e. to cover the TKT infringement. And again, we say this assumes the foresight that the policy has suggested shouldn't be assumed in all cases. And it seems to exclude equivalence where the patentee hasn't drafted the claim in wide terms, and that is unfair on the patentee for the reasons we've gone into already. And he returns to this in paragraph 80, where he refers to the principle of drafting in general terms by reference to old statutes and whether or not they cover new improved methods of transport. But of course, if you've drafted your patent or your statute in general terms, you don't need to go to equivalence at all, because it's still a literal infringement if it falls within the general terms of the claim. So this, A, is unfair on patentees, and B, is no answer to the requirement to have a doctrine of equivalence. All it is it avoids the question of equivalence if you have drafted in general terms. And then in paragraph 81, Lord Hoffmann acknowledges the problem with new technology cases in particular, and whether you are to assume that the invention works. And this is harking back to the earlier discussion and the points I made in paragraph 75. And he acknowledges that problem under the second protocol question. Then he concludes, after discussing American home products in 82 and Improver in 83, that this really depends on the nature of the invention. And he contrasts the facts of American home products where the invention, as I've said, was to a new immunosuppressant molecule. So asking whether a different molecule works did beg the question, and on the facts of American home products would have required a clinical trial to prove. An Improver, where it didn't matter about the material of the substitution, but only the way in which it worked, assuming it was without defect. And we submit that Lord Hoffman is here saying that you can know it works when the invention is not only about working or not. And so he acknowledges the problem, and we say leaves room for our version of question 2 to be applied in the present case. And my Lord Neuberger may or may not recall that you held at first instance in Amgen that the skilled addressee should be entitled to know that the variant works for the purposes of question 2. And you were reversed on that point by the Court of Appeal, who held that American home products was binding and said otherwise. And we respectfully submit that the upshot of Lord Hoffman's discussion here, contrasting the facts of AHP and Improver, is to leave it open. It all depends on the nature of the invention. And one can see why in American home products it might be unfair to assume it works when asking the question, does the variant work? But in Improver, it wasn't the case, and we say it's not unfair in this case to assume it works because the invention is not about whether it works. As far as solubility is concerned, it's about whether it works as a combination with vitamin B12 when everyone knows that the only important part is the pemetrexed anion, which is completely separated by the time it's administered. So we would say this case is clearly in the Improvered camp as far as question 2 is concerned. And as I've said, the factual point in issue, whether pemetrexed dipotassium is soluble, is nothing to do with the combination invention. Instead, it's akin to asking whether the rubber rod in Improver would overheat or fall to bits. Those are irrelevant questions on a proper understanding of Improver 2 when the invention has properly been taken into account. So, my lords, what's the upshot of Amgen?
Interesting to note that on the issue of novelty, Lord Hoffman thought it was important, paragraph 101, that the UK should apply the same law as the European Patent Office and other member states.
Yes, absolutely. And we say, well, of course, we need to be consistent, and your lordships have...
We've said that on more than one occasion.
Yes, you have HGS is one example, Schutz is another. And we say that Article 2 here clearly is required to be applied by the UK, and we would submit that on the approach of the judge and the Court of Appeal below, it's not being applied properly. So, my lords, where does that leave us? We say there should be a two-stage approach. It's not just an exercise in construction. It's not necessary to have a structured test, although it can be helpful when carrying out the iterative process to have the various factors listed out. We did so in this case because so many continental systems adopt a structured approach, and of course there's become something of a vicious circle. They have adopted the Improver style questions because they saw them being adopted in the UK, but we would submit that the precise way in which they are applied is not the same, particularly in Germany. So we would respectfully submit there are two possible approaches. You could go to a single, just apply Article 69 approach and avoid the sort of Improver questions altogether. There is a tendency to over-literalism if you do that, which we've identified, and we identify the Catnick question, the nutshell question in Catnick, as being quite difficult to apply. Yep. A possible pared-down version of the nutshell question in Catnick is to ask, is it essential that there is strict compliance with a particular word or phrase, even though it is obvious that there is no material effect upon the way the invention works? So that's a sort of stripped-down Catnick question which could be used. Alternatively, we have suggested our own version of the protocol questions in our skeleton, in our written case. And if I may, because in answer to something that Actavis has said, if I can hand up to your lordships a sheet with the improver questions on one side and our suggested questions on the other, and just to show your lordships the similarities and differences between them. And just, this is really just to help address a number of points that activists make in their reply. We set out the various parts of our proposed approach. For question 1, identify the invention of the patent from a consideration of the specification and claims as a whole. That's a conventional approach, already part of UK law following Schutz. Then question 2, determine the meaning of the words, that is the construction process, how they would be understood in the context of the patent. And then question 3 is the equivalence process, which is to ask if it has a feature that's not in accordance with the literal words, ask the following. Part 1, does the accused infringement solve the problem underlying the invention by means which have the same technical effect? That's just the German version of improver question 1, which Lord Hoffmann approved in Amgen and is still used in Germany. Part 2, would this have been obvious to the skilled addressee?
It doesn't really, part 1's a slightly odd question in the present context, isn't it? It isn't a real question here. Does the accused infringement enable or continue to enable the problem underlying the invention to be solved by means which have the same technical effect? I mean, it was the change from bisodium to bipotassium doesn't help solve any problem, does it? Or does it?
Precisely. That's precisely our point, my lord. It doesn't.
So
it's nothing
really,
to do with the.
In other words, really the question is, by making this change, are you interrupting the solution of the problem, which is anyway going to occur for other reasons?
Yes, I mean, there may be some variants in some patents which are far more closely connected to the invention than the variant is here. Of course, we say the invention here is the combination of pemetrexid and B12. And as you say, our submission is the salt makes no difference whatsoever. But
anyway,
so,
with that.
yes, I'm sure that there are clearly other ways of expressing these questions that may be.
Improver question 1 is in some ways neatest for you on the facts of this case.
Yeah.
Right.
Yes, well, I mean, and of course it's not in issue either, so maybe it doesn't matter.
Right.
But it does still, continued use of improver question 1 still causes you to have to ask whether you need to know it works for improver question 2.
Anyway, that's improved improver. Yeah, okay.
Well, that's what Lord Hoffmann thought in Amgen, at least.
Number 2?
Number 2, we say, again, effectively it's the same as improver, but all we're doing is fleshing out the relevant factors which you're entitled to have in mind. And there are various ways in which you can look at this. You can either say, well, if you've got the accused infringement in hand, it's clear that it's soluble, it's clear that it's been approved, it's obvious it works. That's one way of doing it. If you are to do it without the accused infringement in hand, then, and you just have a bit of paper with pemetrexid dipotassium written on it, then we say, well, you're entitled to carry out routine tests to work out whether that's soluble, if that's relevant at all. And then it is also obvious that it doesn't make any material difference. So either way, question 2 is satisfied. And then question 3, again, we just say it's very similar to reflect Article 2 and improver. Would the skilled person nevertheless understand the variant to be excluded from the scope of protection, bearing in mind that you have to take into account equivalence?
In 2, if you are deemed to have in hand the accused infringement, does the date of the alleged infringement add anything to it?
No, it doesn't. Of course, there is a time shift because you, by definition, you don't have the accused infringement at the date, priority date, unless.
Yes, but the reason you need the date of alleged infringement is to have the infringing article.
Yes, that's the only reason.
In hand.
Yes, indeed.
If you take improver question 2, it's very much directed to the constructional approach, isn't it? I do include in improver question 2 the question, would the variant itself have been obvious at the date of publication of the patent? Because if that's included, in other words, would it have been obvious that there was this variant? Would it have been obvious that it had no material effect? If you answer those two questions yes, you rather easily get to a conclusion that since they didn't expressly cover the variant, they can't have intended to cover it at all. So that's all the constructional viewpoint, but I think you're inviting a different approach.
My Lord, yes, we would say that that's it, because it has to be a separate exercise of construction, and that approach which your Lordship has just outlined ignores all the policy arguments we looked at earlier, that the patent is meant to cover obvious equivalence. The patentee is not expected to write all obvious equivalence into his specification or his claim.
And anyway, he can't here because although he knows, you say, that there will be some equivalence, there's no obligation on him to do all the work to find what they are and then to specify them. He can just rely upon equivalence being, so to speak, protected.
Absolutely. That's we say that's the right approach. So, my Lord, we say on our version of the questions, there are no new facts required to be found. All of these issues have been raised in the courts below. Contrary to Actavis's submissions, these are not a radical departure from the current approach, and they merely seek to bring together previous guidance. They're not one-sided. They still cater for reasonable legal certainty for third parties, and they're entirely in accordance with the protocol. We could have a debate about the discoverable element of question 2 and whether that's provides fair protection for future inventions, and it might not have done in the Amgen, the facts of Amgen. That's not necessary to do on the facts of this case, because we say it was clearly discoverable at the priority date and therefore should be deemed to be included if that is the relevant date to include.
On the third question, the real difference is simply whether one's looking at the language of the claim or the purpose of the claim.
Yes, I think that's right.
Sorry to interrupt. Yeah.
But we say that the simple approach is that equivalency must be identifiable by the notional skilled addressee with the variant in hand using their specialist knowledge. This includes routine tests, but that's entirely conventional and permeates all aspects of patent law. Many claims contain limitations that require some sort of testing to know if they're satisfied, from taking out a ruler to looking under a microscope to carrying out an NMR test to work out whether a particular chemical is present. And so there's nothing unusual in our suggestion that you should have the alleged infringement in hand when trying to determine whether or not it is a relevant equivalent. And as I said earlier, otherwise, equivalency could never be demonstrated in an empirical field such as chemistry or biology, and this would unfairly discriminate against a whole class of patents. And we also submit that it would be completely artificial to allow an infringer to carry out routine work to develop a variant, but to prevent the patentee from being able to do the same thing under the doctrine of equivalence. I said I'd refer you to the judge where he referred to this as being conventional, and this is in the judgment, if I may, at core volume 2, tab F, paragraph 66. although the judge is quoting himself in another case, which no doubt had different facts, we do note and rely on the fact that he is talking about solubility, aqueous solubility of chemicals, and he says, by a matter of routine, the skilled person would start by ascertaining certain physical and chemical properties of that substance, e.g. its aqueous solubility from the literature, or by routine testing, and that's all part of the common general knowledge. So we say, asking the question of equivalence by donning the mantle of the skilled person with the common general knowledge, we say it's absolutely plain that routine testing, such as to determine whether or not a salt is soluble, would be part of that common general knowledge and therefore is a permissible approach under any doctrine of patent law, but particularly the question of equivalence. And we've seen how that's reflected in the German approach and the questions that the German Court of Appeal have asked their expert. Finally, on question 3, as your Lordship noted, it's all about adopting the right attitude when asking the question and carrying out the analysis on question 3. If you're looking and taking account of equivalence and not merely using a language-based analysis or approach, then we say you are complying with Article 2. Article 2 requires the addressee to have the equivalence in mind and therefore should ask the question whether they should be taken as excluded, and if there's no good reason to exclude them, you should include them. And that means, by that we mean variants to elements that are not essential to the invention. Now, Actavis' 2 responses to this is to say, firstly, Lilly should have used more general wording, but in almost all cases where equivalence is in dispute, it's possible to say that broader language could have been used. So really that's no answer. And as I said, if broader language is used, it no longer becomes a case of equivalence, but it's actually a case of literal infringement. And the other point they make is this, what can be described as faux concern for the patentees. And we say some caution must be applied to this concern, coming as it does from the biggest generic company in the pharmaceutical world. And they say, well, any doctrine which extends the width of the claims potentially makes them invalid or more invalid, and therefore they should be construed narrowly in all cases to be fair to the patentee. Again, we say that if that doctrine is to be applied in all cases, then you would never have a doctrine of equivalence, and so it can't be right to do so. And the way to deal with this issue, if it's a real one, is to challenge validity at the same time as infringement, apply the squeeze, as invariably happens in the UK, but has not happened in this case for good reasons, no doubt, on the part of Actavis. So we would say that the logic of Actavis' approach is to read out equivalence in all cases, and that's contrary to the protocol. And in terms of balancing the rights of the patentee and the interests of third parties, their approach merely piles everything into the third-party side of the scales, and that's not in accordance with the protocol as we're required to apply it. So, my Lords, final topic on UK law is to look at the judgment of the Court of Appeal and where we say they went wrong. And I hope it will be apparent now from what I've already said where we say the errors were made. So if we can pick it up, it's core volume 2, yep. Tab C.
Yep.
And if we can pick it up at paragraph 63. And this is where Lord Justice Floyd is analysing, first of all, Improver question 1, and he holds that all of Actavis' proposed products work in the same way and solve the problem underlying the invention by means which have the same technical effect. This was agreed between the parties. We say this is highly relevant, obviously, for question 1, but also for the assessment of both questions 2 and 3. It's clear that you should be allowed to take into account for the purposes of question 1 that these products are bioequivalent and have been approved, and we say that's also a relevant factor when you have the right information in hand for question 2 as well. He then goes on to analyse question 2 in paragraphs 65 onwards, and he summarises the technical evidence, which I've already referred to you to in 65, that the chemist would be reasonably confident that he would come up with a substitute. And I've shown you the references earlier in the judgment where he says that such a test would be routine, a salt screen would be routine. So he held, and the judge held, and Lord Justice Floyd agreed, that even though he would be reasonably confident to come up with a substitute, this was not enough because the skilled addressee could not have known in advance whether any of Actavis's proposed products were soluble. Now, our criticisms of this are twofold. Firstly, it assumes the wrong level of knowledge, and secondly, it doesn't take proper account of the invention at all, so it's wrong to ask the question of solubility at all. As to knowledge, we say there are two ways of approaching this. Either you have the product in hand and you can see that it's soluble, or that the skilled addressee is allowed to carry out routine investigations to determine whether or not the variant is soluble. If you have the variant in hand, the question answers itself. It's clear from looking at it that it's a liquid, it's soluble, it's approved for patient use, and it's common general knowledge that it must be soluble, as the judge found. And if the point of question 2 is to allow a third party to work out with his product in hand whether or not it infringes, then this is a fair way to approach this question. It's a practical one addressed to the particular product or process in question. And we say that's why question 2 must be asked with the knowledge of the relevant features of the product, of that product or process, as a third party would have. After all, if you are to test literal infringement, you must have knowledge of the product or process. Why not the same question with equivalence 2? With a contractual breach dispute, you have the breach in front of you. You should be able to test equivalence with the alleged infringement in front of you and ask the question that way. Alternatively, if you're deemed not to have the product in front of you, we say that the Court of Appeal ignored the evidence that the skilled team would have a reasonable expectation that there were other soluble versions of pemetrexed which could be found as a matter of routine salt screening. And the particular reason for this is expressed by Lord Justice Floyd in paragraph 50. Perhaps I could take you to that.
Yes.
And effectively, Lord Justice Floyd there suggested it wasn't open to Lilly to argue this routine testing point for him. And I'm afraid Lord Justice Floyd was just wrong to suggest that this wasn't the way that the argument was advanced in front of the trial judge. The evidence, it was advanced in this way. The evidence was there to support it. It was the evidence I've just referred to that there was routine salt screening and that there was an expectation that you would find the salts that were soluble. And we refer to this in paragraph 184 of our written case. And we give the references where we ran the argument before the judge, and this hasn't been disputed by Actavis in their reply. So we say that effectively there's no answer to the point that Lord Justice Floyd takes in paragraph 50. It's wrong, and on the facts that he repeated in his judgment and the judge had found, we say we shouldn't have held that we hadn't put the point below in that way, and he should have adopted the facts and held that it was routine to find the variance in issue in this case on the facts the judge found.
Thank you.
And this is, he returns to this in paragraph 68, where he holds that the relevant question as far as this patent is concerned, and the problem is that the skilled person does not know and cannot predict whether any particular variant will be sufficiently soluble to work. Now, it may be right that the skilled person can't tell in advance which particular salts in a routine screen will be soluble, but because he expects some of them to be soluble, and it will be completely routine to find out which ones they are, this is all a matter of common general knowledge, which the judge had found and should therefore lead to a positive finding for Lilly on question 2. It's clearly discoverable in the German sense and obvious in the sense of there being no inventive step required to reach pemetrexed dipotassium etc., and that should all be enough to satisfy question 2. The other point that the Court of Appeal took in relation to question 2 was the suggestion that by asking it in the way that Lilly proposed, we were trying to feed information to the skilled team about variance, which is impermissible because that information cannot be found in the specification or in the common general knowledge. And this, I'm afraid, is an example of the muddling of the exercise of deriving the meaning of the words and of defining the scope of the claims. And if properly understood, this is not an exercise in construction. As I explained earlier, we are not suggesting that the meaning of the words changes over time with the development of various improvements. And on that basis, it's not impermissible to look at the infringement and ask the question of whether it is an equivalent. And we see this exemplified in paragraph 49 of the judgment, where Lord Justice Floyd made this point, and he suggests that there is a problem with having knowledge of the infringement because it might change the meaning and because the improver questions are an aid to construction. And as we've already discussed, we respectfully suggest that's the wrong approach. And therefore, if it's not an exercise in construction, you are not doing any damage to the meaning of the words by importing knowledge about the infringement when you ask the question of equivalence. And we pose the question, could the modern day builder even use a calculator to work out the transfer of forces in Catnick? And on Actavis's approach and the Court of Appeal's approach, apparently not, because that would be importing knowledge which is not available on the face of the patent. We say that's an unreal approach and, as I say, muddles the exercise of construction and that of defining what the equivalents are. We also submit that Lord Justice Floyd's approach is contrary to the approach of all the other countries, the leading jurisdictions we've looked at, especially Germany and the Netherlands, where either the discoverability principle is taken in Germany or in the Netherlands, express allowance of the common general knowledge at the date of infringement is permitted. And again, the effect would be, if Lord Justice Floyd was right, that you could never have equivalence in an empirical field. The second point, which the Court of Appeal took, is in paragraphs 69 and 70, and this is where we say they focused on the wrong problem and they didn't take proper account of the invention. The problem addressed by the patent is a therapeutic one, not a manufacturing one, and although this was recognised by the judge to be a powerful argument, and he said in paragraph 128 that he had considerable hesitation in rejecting it, we say that properly understood he was wrong to do so, and he should have focused on the proper understanding of the invention, which is the combination therapeutic, which has nothing to do with manufacturing. Now, Lord Justice Floyd agreed with the trial judge's analysis of paragraph 71, and he repeated effectively what he'd said in paragraph 68, that is to, and also fed in the manufacturing wording from the claim. We've explained that a proper interpretation of Swiss claims means that the skilled reader would ignore the legal fiction of the manufacturing step when coming to consider the invention, and they would see the invention for what it really is, that is to say, the use of the medicament together with vitamin B12, a new combination medicament to treat cancer. And once that is seen, the question of solubility of the variant salts is not relevant to the invention in Lilly's patents for the reasons explained. The problem is the toxicity of pemetrexed. The original source of the pemetrexed is irrelevant to its toxic and anti-neoplastic effect, as the Court of Appeal found in paragraph 63, and the solution is to administer it with vitamin B12. None of it concerns the form of the salt. And we would say the solubility point, which the judge took, is akin to the risk of overheating of the rubber rod in improver. It may be a relevant feature if you have to administer this drug to patients. It's not part of the invention, and the variant should be deemed to be soluble for the purposes of analysing whether the variant works in the same way as the invention. And this is all because otherwise you'd exclude unfairly obvious variants which would be easily found by the skilled person at the relevant date. And all of this follows because Actavis's products have to be approved as a generic equivalent. They have to be soluble, and that's something which the court is entitled to take into account when asking question 2. It's not unfair to assume that it's an approved product. To do so is really, to ignore that, would make the law of patents unreal. Actavis clearly expected to be able to generate an alternative product, have relied on Lilly's previous work on pemetrexed disodium to obtain authorization to sell pemetrexed diacid, and the evidence was that Actavis launched these proceedings before they had any data for any of their products. So they clearly expected to be able to obtain a viable alternative to pemetrexed disodium, and they did so in a routine way, consistent with the expectations of the skilled addressee. So for all those reasons, we say that the skilled reader of the patent would expect generic equivalents to be within the scope of protection, and question 2 should be answered in the affirmative. So then we get on to question 3 and the Court of Appeal's analysis of that. Ms. Justice Floyd does this in a single paragraph, paragraph 72, which has a number of subparts. And as I've said, this is really only a different way of asking whether Article 69 is satisfied. And the criticisms we make of the Court of Appeal is that they paid insufficient attention to the equivalence question because of over-adherence to the literal wording of the claim. This is not a case where any other salts of pemetrexed are disclosed in the specification but not claimed, and consistent with the decision of the Bundesgerichtshof, there has been no selection decision by Lilly to exclude other salts.
Yep.
Yet the judge and the Court of Appeal both placed undue weight on the language used at the expense of asking whether Actavis products were inessential variants which the skilled person would consider that no reasonable patentee would have wanted to exclude.
Is this ultimately demonstrates the accuracy of what Lord Hoffman said, that the improver questions don't really have to be answered if you've construed the patent?
Well, it does. We certainly say that's the mistake the Court of Appeal made here.
I mean,
they construed it.
Yes.
They construed it without taking into account equivalence, and therefore found that Actavis didn't infringe. And that's the problem with doing it as a method of construction. I entirely accept, my Lord, that it may not always be useful to ask the improver questions.
Well, no, I was wondering whether this actually illustrates what Lord Hoffman said, that it's not actually useful to ask the improver questions once you've construed it. Because it's basically saying dipotassium isn't included.
Yes.
Therefore, we go through the improver thing, but say it's not included. So
yes, precisely.
Yeah.
That's entirely my submission, my Lord. But of course, the Germans do find it useful to ask this as a separate exercise.
because it's not in construction.
Yes, absolutely.
Okay.
Absolutely. And so this is the Lordship has been my submission. The Court of Appeal and the judge both placed undue weight on the language used at the expense of asking whether the products were an essential. And we see that in 72(1), little 1, where Lord Justice Floyd refers to a single chemical, a highly specific chemical compound, no obvious leeway as a matter of language.
The point I've got is Lord Hoffman at 69 in Kieran Hamgen. There's no point in going through the motions of answering the protocol questions when you cannot sensibly do so until you've construed the claim. In such a case, the present, in my opinion, in such a case, they simply provide a formal justification for a conclusion which has already been reached on other grounds.
Yes.
And that is, I'm right, that's what you're saying.
Absolutely, my Lord.
Sorry
yes.
to.
And we say, of course, effectively what's happened here is Lilly is being penalised for having a patent which refers to a chemical where precision of language is routine. And such precision does not exclude the doctrine of equivalence and shouldn't do that. Otherwise, you'd be discriminating against whole fields of technology where precision of language is possible. And the opposite would be, it would just encourage woolly drafting. It would encourage people to write claims which are so uncertain because they have all sorts of, trying to take into account all sorts of possible equivalents, whereas...
There's a peculiar problem for chemical patents for chemical formulae or chemicals.
Well, yes, I suppose it could also be a problem with where you've got measurements in a claim, numbers in a claim. But it certainly, most pharmaceutical patents would be affected in one way or another by the strict approach excluding equivalence where you refer to a chemical. And of course, under TRIPS, you're not allowed to discriminate against any type of invention. You have to give equal effect to all of them. And the Court of Appeal's approach is to discriminate against patents in this field. if such precision is required and then adhered to without any equivalence being allowed to be
Sorry, I
taken
was
into
interrupting
account.
anyway. Thank you.
So, my Lord, if I take just the points under the subheadings in 72, little 1, what the judge does is he contrasts the class of antifolates generally, which were excluded, and the single chemical pemetrexed. But what he ignores is the pemetrexed salts in the middle. So he is contrasting two different classes, but he's ignoring the middle. And so his contrast doesn't actually assist him because he doesn't address and he fails to engage with the fact that although the patent refers to antifolates as a class and to pemetrexed disodium, there is no reference to pemetrexeds as a class. So the addressee can have no preconception as a result of what is included in the specification but not claimed as to whether other pemetrexeds are intended to be included or not. And by pemetrexeds, I obviously mean pemetrexed salts. And this is why the Bundesgerichtshof decided that there was no selection decision. And we say that Lord Justice Floyd's conclusion in paragraph 72.1 is contrary to the reasoning of the Bundesgerichtshof. In subparagraph 2, he tries to construe pemetrexed disodium rather than considering equivalence to pemetrexed disodium. And that's, again, the problem we've talked about and the obvious wall that you come up against if you try to say that pemetrexed disodium means pemetrexed dipotassium. That's a very difficult concept to grapple with. We don't say that. We simply say that pemetrexed dipotassium is equivalent to pemetrexed disodium in the context of this invention. Paragraph 3, he refers to the figurative sense and whether it's being used in a figurative sense. Really, this is an extension of the same point. He's trying to use the construction approach to decide whether or not the two pemetrexed salts are the same, and that is the wrong approach and difficult. But he also doesn't say, he then goes on to say it's not clear what the class could be when the sodium salt is the only known salt, and it can't be folates generally. But that, of course, just repeats the error he makes in subparagraph 1, because he's ignoring the undisclosed middle, that is to say, different pemetrexed salts, which are not different antifolates, nor are they pemetrexed disodium per se. And so you can't get any assistance from the specification when that intermediate middle hasn't been addressed. In subparagraph 4, he comments that the only data is for pemetrexed disodium, and he says broader claims therefore lack support and may have been unacceptable to the EPO. With respect, that is taking into consideration impermissible aspects of validity, which is irrelevant and wasn't before the court, and he shouldn't have done so. And that's straying into the error which we pointed out, that in any case where you're arguing about equivalence, you could say that making the claim broader might make it more invalid, but that is not a permissible approach when validity itself hasn't been put in issue. And Actavis could have put it in issue had they wished to, but they elected not to for tactical reasons. 5, he contrasts between the general language for B12 and the folic acid and pemetrexed. The difference in language is unsurprising when pemetrexed disodium was the only pemetrexed that was approved for use in patients at that time. It doesn't mean that the skilled addressee would not understand the patent to encompass other forms of pemetrexed. And this was precisely the argument that Lord Diplock rejected in Catnick. In Catnick, it was pointed out that some of the other elements of the claim had more general wording. Lord Diplock said that wasn't a relevant consideration. He only needs to look at the element he was focusing on. And we've also seen a little earlier the words of the enlarged board in Esai, where they say that the doctrine of expressio unius should be applied with great caution. Yeah. And Lord Hoffman himself described the doctrine as perilous in National Grid and Mays at 2001, One Weekly Law Reports 864 at paragraph 55. So we say that's not a useful or helpful approach to construction to take. Finally, little 6, it said that there may be reasons why you want to narrow, but of course there are also reasons not to exclude equivalence. And so by only taking into account possible reasons to narrow the claims, the judge didn't ask the equally fair question posed in Catnick as to whether there was any plausible reason advanced as to why any rational patentee should not want to place so narrow a limitation on his invention.
Yeah.
As we put it the other way, is it essential that there is strict compliance with a word or phrase, even though there's no material effect upon the way the invention works? We say not so in this case. And we contrast this, of course, with Actavis's frank evidence that the only reason for not wanting to use the sodium salt was to seek to avoid infringement. That's not in dispute.
Why did the German court refer the matter back to the Oberlandesgericht or wherever it referred it to? Was it simply because it wasn't clear that the bipotassium worked in the same way, or that was discoverable reasonably by a skilled person?
Yes, I think the answer is that the first instance court decided all three questions of the German test in favour of Lilly. The Court of Appeal only looked at question 3, and they said, you lose on question 3, so we don't need to decide questions 1 and 2. So Bundesgerichtshof reversed them on question 3 and have sent it back for question 1 and 2. But of course, our position is...
you say we got the answers to those questions?
Yes, because they've already said it's discoverable, which is why they held against them wrongly.
And it works in exactly the same way, you say?
Yes. Now I accept that those issues are still alive in Germany. And I think it's right to say that activists are disputing the German question 1 in Germany, even though they admitted it here. So those points are alive, and no doubt the Court of Appeal will look at the evidence from the expert to determine them. But we say, so far as it goes, the first instance court has made findings of fact which are in accordance with Lilly winning, and they should do again. And certainly on the facts of this case in the UK, if you apply the German questions, the answer is that they infringe. So, my lords, in summary, we say the fundamental problem that the trial judge and the Court of Appeal made is they ignored the invention. And this is clear from 72(1), where Lord Justice Floyd states the invention is clearly limited to pemetrexed disodium, and he didn't analyse the invention properly. It's not a case of simply asking whether pemetrexed dipotassium is the same as pemetrexed disodium. The question has to be asked in the context of the invention. Yes, are you reducing the toxic effects of the pemetrexed anion in the same way? And when you ask the question in the context of the invention, the cation associated with pemetrexed is the archetypal non-essential element. This illustrates the problem with an analysis that focuses unduly on the language of the claims just because it's precise. It amounts to saying that you can never have equivalence unless there's general wording used, but if you use general wording, as I've said, you don't need equivalence, and it would imply that the court could never take account of variance where claims recite a chemical compound, and that would be contrary to Article 2, and it would unfairly discriminate against patents in this very valuable field. So for all those reasons, my lords, we say the Court of Appeal fell into error, and both questions 2 and question 3 should be answered in Lilly's favour, as the Bundesgerichtshof did. So, my lord, I think that takes me on to my final topic, which is the foreign law aspects. And the submissions in relation to Italy and Spain are very straightforward. They are that the judge fell into error in relation to Italy and Spain for the same reasons as he fell into error in relation to the UK, and that if we're right about the UK, then you should reverse his findings in relation to Italy and Spain. The particular points arising in relation to these jurisdictions are as follows. Firstly, the Court of Appeal had almost nothing to say about issues relating to the foreign designations of the patent, despite the fact they were fully argued before it. There's just a single paragraph, paragraph 94 of Lord Justice Floyd's judgment, that deals with direct infringement, and no reasoning is given at all. And you might well understand why Lilly feels aggrieved that, having been forced to have the issues of these foreign patents heard in the UK by activists, points worth hundreds of millions of euros a year have been apparently dismissed in a single paragraph, where activists' position is that as these are issues of foreign law, these are matters of fact and they're not capable of further challenge. Nevertheless, my lords, we do confine ourselves to saying that the judge applied the foreign law wrongly. I'm not asking you to make further findings of foreign law contrary to what he's already found. And for these reasons, we say that all our arguments on foreign law follow from the points I've already made to you on Article 69. prosecution history I'm going to leave over, if I may, until reply. As I indicated to my learned friend and to your lordships earlier, it's easier to sweep all these up together. But we say our primary position is that there's nothing in the prosecution history that comprises anything that could be said to be a limitation to the scope of Lilly's claims under any relevant laws. And this is, as the Bundesgerichtshof have already found, and we say that the same finding, even if you were to take into account prosecution history, should follow here. So, my lords, if we just take the judgment, and I can point you to the relevant paragraphs.
Which judgment? First
this
instance?
is the first instance judgment, my lord, which
Thank
is Core Volume 2, Tab F.
F, yeah.
And if I deal with Italy first, because it's the most straightforward. It's page 503 in the physical bundles.
Yes, we see that one, paragraph 166.
Paragraph 166 is where the judge begins, and he recites the agreed law. The only point I need to take from which is Article 69 EPC and the protocol are directly applicable in Italy. That's him summarising the joint expert report in 166. And then if you turn, please, to paragraph 178, first sentence, counsel for Actavis did not argue that pemetrexed diacetyl, dipotassium and ditromethamine were not equivalent to pemetrexed disodium under Italian law. So in spite of the fact that Italy is agreed to be applying the same law as we are, Actavis did not argue that their products were not equivalent under Italian law. And the only point that they ran was that there was a conscious intention of the patentee to limit the claims to pemetrexed disodium. That's,
Yes.
I suppose, the same as question 3, and also because of the prosecution history. And so, my lord, if we're right on question 3, we say there's no conscious limitation. And if...
So that's Italy, right?
That's Italy, yes.
Okay.
Spain is similarly simple because the judgment starts at paragraph 180.
Yes.
And the judge sets out the agreed statements, and then he deals with it all in a single paragraph, 187. And he holds that because of the reasons he gave for finding against Lilly on question 2, he finds against them in Spain too, and for the reasons he found against Lilly on question 3, he finds against Lilly on question 3 in Spain as well. So, my lord, we say that the conclusions you reach in the UK apply equally to Spain. And one important point, it's not in dispute in Spain that the skilled person has knowledge of the variant. And so, for the reasons already given, all of Actavis's alternatives were obvious to the skilled person at the priority date for the purposes of question 2. So that's Spain,
Right.
where the judge just effectively rubber-stamped his UK decision. Finally, France. France is slightly more complicated because of the particular doctrine adopted there to deal with equivalence. And in Lilly's submission, the mistake made by the judge is effectively the same as made in the UK, in failing properly to take into account the nature of the invention. But I'm afraid it does need explaining in the context of the French terminology.
So which paragraph is it?
Sorry, this is, it starts at 159.
Yeah.
And this is where the judge is quoting from the joint memorandum agreed by the parties' experts. And there are a couple of points, if I may draw to your attention this. The third bullet point in 159, he notes that the experts agreed that case law does not constitute a real source of law. Only legislation, whether or not codified, administrative text is applied by the courts.
Yep.
And then the last bullet point above the heading Doctrine of Equivalence, where they say it's nonetheless true that homogeneous sets of case law may have an influence on the way the courts rule, as do the rulings of the Supreme Court, since the role of said court is precisely to harmonise the case law of the lower courts. So from that we take that there is no real doctrine of precedent in France, and first instance judgments and even judgments in the Court of Appeal are really of no value as precedent, but there is some precedent from the harmonising rulings of the Supreme Court.
Seems to be a rather surprising omission of any reference to la doctrine, which I think is quite significant, isn't it? Perhaps
Yes,
one's not allowed to.
I'm afraid this was the evidence that was before the judge, my lord. So
Yes.
we have to take it as it is. Anyway,
Yes.
could I ask your lordships now on the next page? Could
Yes.
I just ask you to read the 4 bullet points under the heading regarding European patents designating France? Said provisions are directly applied by the courts. So it's just starting with however, and those 4 bullet points.
Oh, well, here is a reference, the subject of a doctrinal definition widely adopted by the courts.
And you've got doctrine on third bullet point as well.
Yeah.
Doctrine, no. Yes.
So what the French courts do, my lords, is they distinguish between moyens généraux and moyens particuliers, general means and specific means. And the point of the distinction is to focus on the invention. And so they ask themselves, is the patent teaching a way of doing something new for the first time, that is moyens généraux, or is it merely teaching a new way of doing something old, that is moyens particuliers? And it's the way that the French courts use to try to express the invention at the right level of generality. And so in a novel function, the means is understood generally. Its scope includes equivalent means of fulfilling that new function. But if the overall function is not novel, then the claim is understood to be limited to the specific means expressed. So that's how we would characterize the French approach. And this is how the judge described it in paragraphs 160 and 161 when he went on to analyse this. And could I ask your lordships please to read those 2 paragraphs?
and 161.
Yes, my lord.
Yep.
And we have no problem with the statements of law that the judge
Good.
has made in those paragraphs. But in applying that law, he failed to have proper regard to the invention and the clear evidence that in combination inventions, if the overall function of the combination is new, then it should be regarded as moyens généraux. And so that's what he failed to go on.
He treated it as moyen particulier.
He did.
And
He said
therefore
no
it's limited
equivalence.
to sodium.
Yes. Yes.
But you say he went wrong, wasn't moyen généraux.
Yes,
Okay?
we say effectively he made the same error as he made in relation to the UK in failing properly to appreciate the invention, because the invention is the administration of the combination of pemetrexed together with B12, and this combination imparts a new function which didn't exist before, because neither the pemetrexed nor the B12 had delivered efficacy without toxicity. And B12...
So he goes wrong in 164, really.
He does, yes, that's where he applies it.
You say, yeah.
Importantly, vitamin B12 has never been known to be an anti-toxicity agent generally, and it only...
It basically inhibits the toxic effect of this.
Of the pemetrexed, yes. So the functional role that each of the elements adopts in this invention is adopted for the first time when they're combined, and the judge lost sight of that, and he should have treated it as a moyens généraux.
Thank you.
So his summary in 164 overlooks the central facet of the invention, and he didn't analyse in this paragraph nor acknowledge any of Lilly's submissions in relation to combination inventions having a new function at all, even though these were made clearly at the trial.
Yes, I see.
And I'll show you, we made those submissions at the trial in closing submission. He was wrong to ignore them. And there were 2 things we relied on before the judge, which I would like to show you if I may.
Yes.
First is an extract from a textbook, which conveniently was written jointly by both parties' French experts in 2012, before either of them had been engaged in this
Where do we
litigation.
find that?
My lord, that's at bundle APP3, which is French. Appendix Part 3, France. It's called. Tab the last tab.
24.
What is tab 24?
Tab 24 is an extract from a book that's been written by the two French experts, and it doesn't look very attractive in this translated way without any of the background material. So I have got to hand up the original French.
Industrielle.
I'm sorry, my lord.
I'm just saying it's droit de la propriété industrielle.
Yes, indeed.
7th edition, this one. You want us to read it?
Yes, please.
Okay.
Thank you.
Yes, I see. Thank you. Yeah.
So, just to be clear, my lord, this came from a book written by Professors Azima and Galou
We have that.
in 2012.
We have
So
that.
it's about as untainted as it could be in terms of material prepared outside the litigation. The professors tackle this combination point head-on in this paragraph.
Yes.
Actavis suggests there is some problem with its admissibility, but this material was in the bundles at the start of the trial, and no objection was taken to it being in the bundles. Indeed, Actavis's own expert relied on other parts of this book himself, and Bird put the extracts from the book in the evidence file rather than the authorities file because it had been cited by the expert. I think the point being taken by Actavis is the technical point that it wasn't expert evidence because this passage wasn't relied on expressly by either of the experts. But it was jointly written by the two experts who did give evidence in the case. Actavis's expert relied on one bit of the book.
Yeah, we have that.
And we brought it to the judge's attention at the trial.
But this passage was neither explicitly relied on nor put to either of the experts.
No, it wasn't put to the experts because there was no cross-examination, my lord. The judge had already held
Understand?
that he didn't need cross-examination. He said most of the issues
Fine.
in doubt were not settled law.
Okay.
And it was before the judge. We made the same point I'm making to you now before him in closing. He just failed to deal with it in his judgment.
Yes, I see.
And we say that the message of the passage is clear.
Yep.
If the overall function is novel, you can have equivalence, which is the position we find ourselves here.
Did you want to refer to something else?
Yes, I do, please. There's one other
Yes.
document, which is an example of this doctrine being applied in a judgment of the French Supreme Court. And as I've said, that's the only
Page,
level.
tab.
This is tab 9,
The same bundle.
same bundle, yes.
I see.
And this decision was introduced by Lilly's expert, Professor Azima, in his report.
Yes. Well, I think you're now in injury time, aren't you?
I am in injury time.
Well,
I'll
then
pray for an extra 5 minutes because of the slightly late start this morning,
Yeah,
if I
well,
may.
very well. But that,
My Lord, this
Yep.
case doesn't decide the point. It merely applies it in the way we say the French experts have agreed it should be applied. So
Yep.
if your Lordship looks on the page 2 of the decision, MS 1344,
Yes.
you'll see in the italic paragraph 1,
Yes.
halfway through the paragraph, this is summarising the appellant's case. They say, in the case at hand, the Court of Appeal found that the claim of patent 1 constituted
Yes.
a combination of known means.
Thank you.
And then in the judgment, which is the paragraph at the bottom of the page, going into the following page, the court holds, on the first two lines, second and third line of the following page, they say, it holds that the new function of the combination of means covered by the patent is fulfilled by equivalence. So we see here the Supreme Court,
Where's the reference to equivalence?
Top of following page.
top of 1345. So we see here the Supreme Court applying equivalence to a combination invention
Yes.
where the combination is said to have a new function. And so we say this is an example where they've looked at the combination and they haven't looked at the individual parts of the combination and asked, are those old or new, but they've looked at the function of the combination altogether. And that's what we say, entirely consistent with the French experts, is what the judge should have done. And if he had done that, he would have determined that this was a moyen généreux case where the function of the pemetrexid disodium together with the B12 is new, and that should have allowed him to make a finding of equivalence. Instead, he salami sliced the invention and salami sliced the way in which the pemetrexid disodium works together with the vitamin 12 out of his assessment altogether. It is a new global function reduction in toxicity. The only material before the judge were these two documents on this point. And we say there was no reason, nothing for him to determine the case against us if he had thought about this issue. Therefore, he was clearly wrong to ignore it. My Lords, that concludes my submissions on direct infringement, unless I can assist you any further. That's Lilly's appeal.
Thank you very much indeed. Mr. Moore, we're hearing from you on Thursday morning, I think. Is that right? Thank you very much. Mr. Alexander.
My Lords, what I propose to do is address the following issues. First of all, the facts relevant to the appeals, including making a few further observations on the patent, the file, which is, of course, of relevance not only to our case on the prosecution file's admissibility here, but also because the file plays a role in each of the national jurisdictions that your Lordships have to consider. And the expert evidence that I would just like to remind your Lordships of relating to the manner in which a skilled person would be approaching the disclosure and the specification of the patent. I can try and take that quite briskly because there's no error identified in the findings of the judge or the Court of Appeal in relation to the common general knowledge on that aspect. Secondly, principally in response to Lilly's main appeal, I will address the applicable English law on scope of claim with a short detour into some comparative illustrations. As your Lordships appreciate, our central submission is that the overall approach taken by Amgen, if one, as it were, properly construes Amgen, is correct, and, if I may say so, increasingly recognised as valuable by those in continental Europe. And to some extent, the approach, as your Lordships see from the adoption of either the improver questions or adaptations of the improver questions in other countries, has been influential in those countries. And hopefully I can take that fairly briefly in the morning. Thirdly, I'll deal with the points raised by Lilly. I think one of them has sort of fallen away, but one of them is that Ms. Justice Arnold and the Court of Appeal got their evaluation of the second and third questions wrong in this case, and there's also the question that I think has fallen away is that equivalence for the purposes of patents ought to be determined by bioequivalence, effectively, in the regulatory regime. So I can take that rather briskly. And then that's to say Mr. Raphael and I will address the specific arguments based on the foreign jurisdictions, France, Italy and Spain. I'll deal with France, and Mr. Raphael, subject to my Lords, will deal with Italy and Spain. And at some point we will interject a section on the travaux, which your Lordships have seen some of, for EPC 2000, to just ensure that your Lordships have got the picture in relation to that. My Lords, I think, have our overall submission, just by way of overview, that this is, in substance, a straightforward case to decide, although there are wrinkles, if I may put it like that, in relation to the approach that your Lordships are invited to either adopt, modify, throw overboard with respect to the determination of equivalence in this country. When I say equivalence, effectively the task for the court in a case of this kind is to determine the correct approach to determining the scope of protection Indeed, that's the title of the various headings of the statutory and treaty provisions, and everything is encompassed under that. Our submission is that there is no real warrant for rewriting the established law on that point, and that if one understands that when Lord Hoffman was using the term construction to refer to the task that a court had to undertake in determining the scope, he was, if I may respectfully say so, using that term in something of a similar way to the way in which he used the term construction, which your lordships commented on in the Marks and Spencer's case in relation to the implication of implied terms, where his terminology was used essentially to refer to scope of claim without in any way parting from the general proposition that construing the claim in its, what might be called, strict meaning of construction and implication of terms into a contract were different exercises with different incidents and different requirements. So once that's understood, quite a lot of the misunderstanding falls away, and one can see in the foreign commentaries as well that that is how they understand the approach that Lord Hoffman was taking in that case. They don't see that judgment as excluding the scope for equivalence in English patent law. To the contrary, they see it as a way of including equivalence and giving effect to the requirements of the EPC and the protocol as amended. I should say that I will, at the end of the submissions, address the indirect infringement case in the morning.
Isn't it a bit confusing to use the same word in different senses?
My lord, which?
I mean, you're saying that we can accept the use of the word construction by Lord Hoffman as long as we understand it to mean something different from what it normally means.
My lord.
I'm all right, I'm capable of mental gymnastics to a degree, but it may be that it's a bit confusing.
My lord, there would be something in that.
Well, insofar as in the field of contract, Lord Hoffman might be said to have used construction to cover construction, normally so-called implication and rectification, then this uncertainty isn't confined to the law of patents.
Well, that is what underlies my submission.
Yes.
And some of your lordships, if I may put it like this, adopted a more charitable approach to that formulation of the term construction in your evaluation of the Marks and Spencer's approach. Similarly, when one sees it in this way, a lot of the problems and a lot of the alleged differences of approach appear to be differences that are terminological differences,
yes.
rather than differences of substance.
And the reason boxes, as Lord Sumption.
My lord, if I may say so, my lords, that was a particularly apposite analogy, in that if one is concerned not with exactly what the means are, but how to achieve the result that the overall legislation requires. And if one also recognises that in relation to the EPC and the EPC 2000, what the legislators were seeking to do was set a framework within which national traditions for determining equivalence could be and were accommodated, and that a degree of variability in approach was acceptable, and that one has seen that even since EPC 2000, the degree of variability of approach has been applied, recognised, and actually not said to be unduly problematic in different member states. Some of these problems simply disappear. But perhaps I'm getting ahead of myself a little bit.
That I do find a bit puzzling. I thought the whole point would be uniformity across Europe. Wouldn't it? I mean, isn't that what the international organisation was striving for by the 2000 amendments? And isn't it what,
My lord,
up to a point, we were all at one point striving for?
I'll come on to that in slightly greater detail when I address your lordship in relation to the law on that and Amgen. But in our submission, it is, and all of these analogies are somewhat imperfect, but it's a little bit like, like some of the European harmonization, which seeks harmonization as to a result to be achieved without prescribing in detail the precise means by which that result should be obtained in the case of a directive.
I mean, I can see that in many areas. We've been arguing for flexibility, margin, states' rights to set their own standards. But in the area of patents, I just wonder whether this isn't an area where you wouldn't expect a good deal of homogeneity. Otherwise, you get the odd situation of something being patentable in one place and not in another. And so on.
Well, my lord, if I may just...
different things.
If I may get ahead of myself with some of the arguments, just to answer my lord's points, that desire for uniformity has been expressed in what might be called partial legislative form by the moves to create a unified patent court that some of your lordships may be aware of. The idea there is that for European patents, one can opt in or not opt out one's patents, and that they will be the rights will be determined by a central court, or it's more like a district court system, throughout the relevant contracting territories. And at that point, one might say, of jurisprudential and indeed, one might say, institutional harmonization, it becomes possible to see a complete harmonization.
But one thing to talk about complete harmonization remains the fact that, A, the purpose of the present arrangement is to achieve a significant degree of harmonization, as indeed we saw with the reformulation in 2000. And as we also see from a number of observations in this court in the House of Lords.
My lord, I don't disagree with that in any way. The only question may be the degree of harmonization, not either the desirability of it, or the fact that that was one of the things that was on the agenda. But when one is dealing with harmonization in any field of law, be it here or in any field by an international body, there is a need to be somewhat sensitive, in my respectful submission, to the extent to which complete harmonization is forced upon individual national traditions, and with respect to the question of whether individual national traditions force harmonization on everyone else by saying that everyone else is out of step with us and has to follow our
Part of the
line.
problem in the context of patents is that you've got the unusual situation that there is a single instrument which is produced as a European patent, and any degree of variation means that the very same instrument may be infringed in some places and not in others. Now, that might be regarded as rather more than an inconvenience and rather more than simply the normal consequence of litigating in several places.
My lord, those are precisely the motivations that have driven the establishment of a unified patent system. Because one of the things that one also has to bear in mind is that although there is some degree of disunity of approach, there is equally a very significant degree of commonality of approach as to the central principles, and I shall show your lordships that in greater detail when we look at some of the comparative materials. But that the drive towards harmonization has to recognize that there are imperfections everywhere in the system, and one can have, and one sees in the cases, courts in different countries applying purportedly different tests, reaching exactly the same result in certain cases. And one can have courts in the same country at different levels of appeal applying exactly the same test, reaching totally divergent results. And one sees some of that in the cases that your lordships have before you. So there is a risk, in my respectful submission, in seeking to, as it were, start out with the assumption that one has to have that perfect harmony is achievable, and insofar as it is, perfect harmony should be obtained by us following a given approach that is set out by some other court or is constructed. And I sense that I'm getting ahead into the legal analysis and away from the place that I thought it would be useful for your lordships to start. But nonetheless, the reason for doing so is because that, if one's thinking about issues of principle that affect this case, that might be said to be the big one.
Just a matter of interest, don't spend any time on it. What's happening with the Unified Patent Court at the moment?
My lord, that itself is a question that requires layers of answer. May I try and answer it very simply? The position is that an agreement is made between the majority, but not all, of the EU member states, important member states, Spain, Poland, and I think Croatia, I can't now remember which, have said no. The agreement has been signed and ratified by many, but not by two of the key members, England and Germany.
UK and Germany.
Not yet.
I really am getting ahead of myself. The UK and Germany. I think I can say no more than matters are in a
and presumably people are in a state of flux.
They were in a state of flux, and following the 23rd of June in a greater state of flux than before.
My lord, that is a fair characterisation.
Okay, that's very
Go into it if necessary, but I think it's not for present purposes.
That's very
The only point that perhaps has an intersection with this case is, let us assume that matters go ahead in that court, and that is court is established. There will, in a sense, be a need for that court, however that is done, to establish its own, one might say, sui generis test to the question, or and approach it in that way. It can't be taken for granted that the German approach would apply.
No.
It can't be taken for granted that the English law approach would apply, or the French, or the Spanish, or whatever. There might be some form of blend.
Okay.
So can I then deal with technical issues and start with the patent, which you find in Appendix Part 2. And your lordship was taken to some parts of it, but there are... It's MS 733 in the printed
thank you.
case. Your lordship was taken to parts of it, but there are other parts that are equally important, to which your lordships were not taken. So the first page of the substantive text, so MS 734, is a general description, and in paragraph 4, you see a reference to the explorations of the role of folic acid in modulating the toxicity and efficacy of the multi-targeted antifolate. That is, in fact, pemetrexid disodium, LY231514, as discussed in Warzala. We don't need to go to any of that underlying material. The second point that your lordships should bear in mind is that the specification specifically, if I may put it like that, distinguishes between what it describes as a general aspect and a specific provision. And your lordships see that on the next page at paragraphs 8 and 10, where paragraph 8 says, furthermore, the present invention generally relates to use in the manufacture of a medicament for inhibiting tumour growth and so forth. But then paragraph 10 says that the invention specifically provides the use of the antifolate pemetrexid disodium in the manufacture of a medicament for use in combination therapy for inhibiting tumour growth in mammals, wherein the said medicament is to be administered in combination with the MMA lowering agent selected from vitamin B12 and pharmaceutical derivatives thereof. And that passage is important because what it does, and that is reflected in the claims, is to, on the one hand, identify specifically the antifolate pemetrexid disodium, and to identify generally a group or class of MMA-lowering agents selected from the identified list. Paragraph 11 then makes the point again. The invention specifically provides the use of the antifolate, and paragraph 12, the invention specifically relates to the use of the MMA selected from that class, and paragraph 13, the same point is made.
Well, there are 3 generalies and 6 specificallys.
Indeed. Yeah. And then when you look at paragraph 22, the degree of specificity is identified clearly there. The terms antifolate and antifolate drug generally refer to a chemical compound which inhibits. And then at the end of that paragraph, the antifolate or antifolate drug for use in this invention is pemetrexid disodium, as manufactured by Lilly. And in contrast, again, paragraph 25, the vitamin B12, you have a wider class, and paragraph 28 actually refers in that context to the possibility of physiologically available salts or esters in the context of that particular point. The experimental results which you were shown relate to and only to specifically pemetrexid disodium. Yep. You see that at paragraph 55. And I think the Lordship saw that
we were taken to that.
Already, but it's important to recognise that that is the disclosure in the specification went no further than pemetrexid disodium, and we will submit for good reasons. The claims reflect that, and claim 1, where you have use of pemetrexid disodium in the manufacture of a medicament, you have on the one hand pemetrexid disodium, and on the other hand a class of vitamin B12s. And although I'll try and deal with Swiss claims briefly tomorrow, it's not possible simply to ignore the fact that this is a claim to the manufacture of a medicament. It's something that is self-evident on its face. So that's the claims, the patent and its claims. If I can then just draw your attention to the key points in the prosecution file, and do that relatively briskly with the following prefatory remarks. One might think that a prosecution file is a massive document where working out the parts that are relevant for a case concerning scope of claim is a difficult exercise. In our submission, that is not the case, and one can actually see that by the nature of the file here. As your Lordships will have appreciated, and we've dealt with in our printed case, patent prosecution is a tightly controlled, time-determined administrative approach, where the ultimate outcome of grant is less akin to a negotiation than effectively an administrative adjudication, where the office will say, well, you can't have this because it doesn't comply with the rules, so you'll have to amend in order to comply with the rules, and the applicant then has a choice as to what they do. They can either accept the view of the office, or they can say, well, okay, we reject your view, and we will either call a hearing and seek to persuade you otherwise, or if you are not persuaded otherwise, we will appeal the rejection, because there's a right of appeal of rejection of a patent on appropriate grounds. So this is not one of these situations where there is some sort of nebulous provision. There is a clear, distinct, and importantly, as your Lordships have seen from our case and the extensive references to the materials, public file that anyone is entitled to access, and which now is available electronically at the click of a few buttons, indexed and so forth.
So is what's called the prosecution file, is that entirely in the public domain?
It is entirely in the public domain, and it's required to be in the public domain by the EPC, and I'll give your lordships the references to that if you wish. And there is a rule that says it's now got to be available online, electronically. It's available, it's kept for 5 years after expiry of the patent. It's a record of what might be called the proceedings leading to grant, the basis upon which grant was undertaken. But the point that is perhaps relevant for this aspect is that when one's dealing with consideration of the file, and perhaps one of the reasons why other courts are perhaps more prepared to take the file into account, one is not dealing with a huge interchange ordinarily. In this case, we have effectively 4 letters. Two of them from the office and 2 of them from the applicant, which contain everything one needs to know, and actually quite a lot more about other aspects of the case. It's a document that would invariably be consulted by patent attorneys and those engaged in litigation and so forth. And so perhaps I can just take your lordship very briefly through the way in which matters are developed, if that's convenient. So if we start at tab 8 of Appendix Spot 2, which is 942 of the, paper 946 of the electronic. This was the first examination report, effectively, of the examiner, who was commenting on the application that had been made for the patent, which you don't need to look at for the present purposes, but you'll find in the previous tab 7. And
so where do we look at in here?
The key points are really on pages 1 and 2 of the document.
The bottom of page 1, is it?
Bottom of page 1.
Present claims.
Present claims. If your lordships would just read that. Down to
independent of the above.
Independent of the above, indeed.
Okay, thank you. We'll do that. Yes, I see. Thank you.
And just in passing, you don't need to read it in detail, but it's worth bearing in mind. The examiner didn't just make those objections. There were objections raised on the grounds of novelty and inventive step as well.
Was it just for noting as we go through?
Indeed. It may be useful just to note them and skim, but you could read those in your own time.
Thank you.
So Lilly then comes back, and this is not a situation where an applicant is placed under any pressure as to time. You'll see that the dates of this. The EPO's letter was in March.
Yes.
Lilly came back in December. So after a period of mature and careful consideration, said this. And again, all you need to read is 9 under amendments over to 948, 947 to 948.
Really, the whole passage under amendments.
Indeed.
Yes, okay, thank you.
And you see that the applicant was keen to achieve effectively early resolution of the matter, and there was a reservation in the first paragraph, which your lordships may have marked, namely that the amendment that was put forward, which was said to refocus on the use of the antifolate compound pemetrexed, was without prejudice to the right to obtain protection for other patentable subject matter in one or more divisional applications. And just for those who are less familiar with the application process, a patentee has a choice to some extent. It's circumscribed by rules. As to whether they put everything that they say is inventive about what they have developed into one or more patents. And a single disclosure often gives rise to a set of different patents, which are called divisionals, because the subject matter is divided out from an original disclosure. And so what the patentee was seeking to do here was to obtain specific provision for a specific aspect of what they had invented, specifically and rapidly in this patent, without prejudice to their ability, should they see fit, and subject to being able to satisfy the law of the requirements of patentability, of being able to make other applications broader, different, covering other subject matter, as and when they wanted, subject to compliance with the divisional rules. And that is the reference to the reservation of the right to preserve, to apply for divisionals.
How does the protection work? You get some degree of protection from the first date of your application, do you?
You get protection from the date of publication of the application.
Well, that was back in, that's document 7, which we didn't look at. Yes.
Indeed.
Because that's public, presumably.
But one can't sue for that until the patent is granted.
Yes, I see. So
under Section 69 of our Act.
Yes, okay. So if you actually started to cut back and then applied for a separate patent, that would have a separate publication date?
Yes. It would. Well, the application would be regarded as the original application, but your Lordship is right. There's a separate publication of a divisional application,
yes, I see.
effectively. So yes and no. So then the office comes back, the next tab, MS 959.
Thank you.
And raises an objection to the applicant saying, well, what we want is pemetrexed. And again, if I could invite my lords just to read the passage under amendments and over to inventive step.
Right, but not inventive step.
You don't have to read that, no, but perhaps just mark the existence of it. So what the examiner was saying was, look, what you can't do is simply put in pemetrexed, full stop. You have to actually confine yourself to pemetrexed disodium if you're coming down from the class of antiphthalates, because otherwise that may give rise to an added matter objection, which I can discuss with your lordships tomorrow. But in any event, the letter concluded, you see that on page 962, by saying it should be noted that all outstanding objections should be removed by suitable amendment or explanation in the next letter or reply. Should there still be substantial outstanding matter at that stage, the application will have to be refused, or oral proceedings will be appointed in pursue the further examination of the present application. So they were being told this is their last chance, effectively, to obtain a patent that was in the manner that they were seeking, but of course with the right to appeal. So the next letter, which is in a sense the critical letter, again not foist under pressure of time. This is months later.
10 months, yeah.
Lilly comes back, and again, if I could just invite your lordship.
It's really the first paragraph under amendments.
Exactly. That's
Which
all you
page?
need to know.
First page 963.
Correct. The claims have been amended to refer to the preferred embodiment, the use of pemetrexid disodium as manufactured by Eli Lilly as the antifolate drug. And that is not just the claims, the description has been amended as well.
What about the next sentence?
The claims have also been amended to incorporate the list of vitamin B12 derivatives as set out on page 7. Well, in fact, that reinforces my point.
Sorry, where are we now? Where?
We're still in the first paragraph.
Oh,
So what is being said is, as regards
okay.
pemetrexid, we're limiting ourselves to pemetrexid disodium, full stop. And as regards vitamin B12 and their derivatives, we have amended to a specified list. And the justification for amending to a specified list comes from the last page of that response, MS 965, top paragraph. As can be seen, these pharmaceutical derivatives of vitamin B12 are well known and are structurally convergent. Thus, given this explanation, there is no reason to doubt that the technical effect demonstrated in the examples would extend to the entire invention as now claimed, a proposition not asserted with respect to any other alternatives to the specific pemetrexid disodium salt claimed. So there could not be, in our submission, a clearer indication that this was a limitation of the patent to the preferred embodiment as disclosed and to pemetrexid disodium specifically.
But they were forced to do it, effectively. They were forced to go back to the original term.
My lord, forced is the wrong term. They chose to do it in response to an objection.
Well, they did. That's the point.
They did.
That's your point. I mean, they did have a certain degree of gun against the head in the sense that they risked losing the patent altogether. This
Well-
last chance saloon. But anyway, your point is that that's what they did.
That's what they did, and it is clear on the face of the file that that's what they did. Can I then just, in the last 5 minutes, just take your lordships to two passages from the judgment of the Court of Appeal?
Sorry, what inference are we to draw from your last point?
They
The
withdrew
inference-
a more general claim to a more specific claim of disodium, the disodium compound.
But that doesn't really answer the
No.
question whether, if you have pemetrexid disodium as the preferred embodiment, that you're thereby excluding equivalence.
My lord, what it does is it says that the patentee was seeking to limit itself to the preferred embodiment, and if I may put it like this, confirming in the file that the specificity that on its face appears from pemetrexid disodium was the specificity that they intended, because that was the specificity upon which they were inviting the patent office to grant the patent.
The trouble is,
That's reading quite a lot into the sentence. The claims have been amended to refer to the preferred embodiment.
I mean, the trouble is, as with so often when one looks at negotiations and when one's trying to construe a contract, it may be, or even in looking at an Act of Parliament and seeing what was said in Parliament, it may be that the amendment was made or the concession made because the person concerned thought, well, I have another avenue of argument in due course. Equivalence. I'm happy to limit it to sodium, the sodium version, because I've got the equivalence to fall back on, for example. We just don't know, but isn't that the problem?
Well, that we would respectfully submit is reading a very great deal into what is on its face a specific limitation that is provided.
Are the last two paragraphs on page 964, are they relevant or irrelevant to this debate?
My lord, yes. On
I
964,
don't think that's a question of...
yes, that's the prelude to the
Be asked,
passage
yeah.
that I read to my lord in relation to the contrast
Yeah.
between the vitamin B12s.
Yes. So, sorry, you were going to take...
So that's the file.
Yes, thank you.
And bearing in mind
You're going to take
time,
us to the Court of Appeal.
perhaps what I might...
As Mr. Mitchison mentioned, we started slightly late, so you can have a few more minutes.
Yes, this won't take very long. It's the Court of Appeal's judgment, Core Volume 2, tab 13C, and pages 416
Thank you.
to 417. And the only points that I would invite my lords to have in mind are these. The judge and the Court of Appeal set out, in terms that are not challenged,
Yes.
the common general knowledge of both the oncologist and the chemist,
Yes.
who are members of the team who are the addressees of the patent. And as regards the oncologist,
Yes.
of importance is paragraph 36. At the end, Professor Ferry, Lilly's expert, agreed that the properties of salt forms and free acids were difficult to predict, and that the chemist would need to address this problem by conducting experiments. As regards the common general knowledge of the chemist, I would respectfully commend the whole of paragraph 37 to your lordships, but with particular emphasis on subparagraphs 5 to 9, where a number of key points were made. First, that the chemist, in considering this issue, would know that the salt form could have a significant impact on the effectiveness of the drug in a number of ways. In particular, there was solubility, but not only solubility. By contrast, there might be excessive solubility, which would also create problems, and that in general there can be many dead ends and false leads when attempting to prepare salts of the parent molecule for the first time, that it was not possible to predict in advance whether one could make a particular salt form, what its properties would be once a salt form was made, or whether that would affect the efficacy of the drug. And if I could then finally, on this aspect, just draw your lordship's attention to paragraphs 38 to 41, because they are quite important. Sodium salts had the advantage that they were the most preferred counter-ion. Potassium salts had potential problems with respect to toxicity. Trimethamine salts were in the minority and not high on the list. There was a perception that they might be too soluble and one might not be able to make and harvest the solid form. And as regards free acids, there were potentially issues in relation to adequate solubility and so forth. So if one is putting one's spectacles of a skilled person on, considering the patent, and this is where I would close for this evening, subject to my lords, one would be thinking there is a good technical reason why there has been a limitation to pemetrexid disodium, because actually other salts are different. And if one was looking at the file, one would see that there were good technical and legal reasons why there had been a limitation to pemetrexid disodium, and why the terminology in both cases was sufficiently precise to be intended to exclude everything other than the preferred embodiment actually disclosed and to which there was some experimental data. So subject to my lords, that's where I would draw stumps for today.
Very much indeed. Right, we'll adjourn now and resume at 10:30 tomorrow when we'll continue to hear your submissions. Thank you very much indeed. Adjourn.